this morning's docket. That is case number 110360, State v. Seacat.
May it please the court, Deborah Wilson appears on behalf of the defendant, appellant Brett Seacat. Justice Ness, I'd like to request 3 minutes rebuttal.
3 minutes is granted.
Thank you. This is Brett Seacat's direct appeal from convictions of first-degree premeditated murder, aggravated arson, and 2 counts of child endangerment. He's currently serving a sentence of life imprisonment plus 75 months. Brett contends that his right to a fair trial was violated primarily by the admission of hearsay in which a number of Vashti Seacat's friends and associates were able to tell the jury that Vashti had told them that Brett had threatened to kill her, and in the exclusion of Brett's testimony, his proffered testimony regarding Vashti's previous suicide attempts, and those are the 2 issues that I'd like to focus on today. And I'd like to start with the excluded evidence of suicide attempts. The state knew before trial that Brett would be defending on the grounds that Vashti had committed suicide. The state met that claim by presenting evidence from 9 different witnesses that presented Vashti's public face to the jury, her sunny disposition, her optimism, and her devotion to her children. But Brett was prevented by the trial court's order in limine to let the jury know all those things about Vashti are true, but Vashti also had a private side, and that private side included a history of attempts at self-harm. This excluded evidence was essential to Brett's defense because, as the Utah Supreme Court stated in State v. Yeager, it is reasonable to believe that a person who has attempted suicide in the past may attempt suicide again. But the state blocked the jury from hearing this evidence by convincing the trial court that under State v. Baker, the determining factor regarding the admissibility of previous suicide attempts is the passage of time, and therefore this case required the same result as Baker. And we contend that Baker is easily distinguishable from the case at bar. First and foremost, the suicide theory put forward by the defendant in Baker was physically impossible.
But that isn't what we held in Baker. In Baker, we didn't look at the physical impossibility. In fact, I think in Baker that he gave an explanation of exactly how it happened and that he assisted in the suicide. It was the passage of time in which he was going to proffered some evidence regarding, I think, a prison guard or something that occurred 3 years ago when he was an inmate in a facility. Not an inmate, but in a facility due to his physical disabilities, and that it was the passage of time, and that you couldn't replicate, you couldn't assume from that circumstance at that time what occurred 3 years later. That clearly was part of that.
The passage of time was certainly a part of this court's analysis in Baker, but this court was informed in Baker by its previous decision in State v. Drock. In State v. Drock, this found that evidence of previous suicide attempts is admissible if the facts do not preclude suicide. This court did note in Baker that suicide as the defendant described it, was a physical impossibility for the victim because he had to use his tongue, I believe this court noted, to operate a television remote control. So the glaring difference between this case and in Baker is that in this case, suicide is not precluded by the facts. The coroner testified that she could not rule out suicide in this case, and that's the first major distinguishing feature in this case, and I would submit it's a really big one given this court's decision in Drock and the court's reliance on Drock in the Baker decision. Baker and Drock simply do not require the exclusion of the evidence in this case.
But is it discretionary? But do they leave it to be a discretionary decision with the judge?
Yes, Justice Lukert, your standard of review is abuse of discretion, and we are arguing today that this in fact was an abuse of discretion because the trial court exercised its discretion under the wrong legal standard. When it misinterpreted, we allege, Baker as standing for the proposition that we are only going to look at the passage of time. Returning to your comments, Justice Rosen, you were mentioning that we don't know exactly what happened in the Baker case to place the victim under suicide precautions in his assisted living facility. That's our second major distinguishing feature in this case, because in Baker, the defendant was trying to introduce evidence that the victim was under suicide precaution, but we don't know why. So we don't know if there was an actual suicide attempt that was thwarted or failed. We don't know if there was no attempt, but there was just some language or a threat of suicide. Or we don't know that, in fact, the victim didn't attempt, didn't threaten suicide, but there was just a circumstance in the victim's life that led his caretakers to believe that maybe these precautions were necessary. In this case, Brett Seacat was prepared to testify to actual suicide attempts. So that is another factor that should have gone into the court's analysis when deciding whether this evidence was relevant. I guess what I would say to sort of put it in a nutshell is this. The question is relevance. And passage of time, as this court stated in Baker and in Drock, is certainly relevant. But there are other factors at play that can make certain evidence relevant in one situation with the exact amount of the passage of time that make it not relevant in another. And of course, I'd return to our big one. In Baker, it just couldn't have happened the way the defendant described it. Finally, our other distinguishing factor is Brett was prepared to testify to a series of suicide attempts in this case, which renders the evidence more relevant as to whether Vashti committed suicide on that occasion, rather than in Baker, one incident in which the victim was placed under suicide precautions for reasons that are unknown to us. In State v. Fenton, this court stated that the passage of time between an event in the past and the event in question, it may be more relevant to the weight that should be accorded to the evidence rather than to its admissibility. In this case, we believe that the jury was certainly able to assess Brett's proffered evidence, or should have been able to assess Brett's proffered evidence, and determine the weight that they should give to the proffered evidence. Vashti Seacat, clearly from the record in this case, was a complicated human being who couldn't simply be described as only positive, cheerful, and optimistic. And in light of all the evidence that we had in this case about Vashti's public side, it was fundamentally unfair to prevent Brett from giving the jury a full view and a complete picture of Vashti because her private side was central to his defense.
Even under the evidence that he would have submitted, was there anything that would have indicated a more contemporaneous suicidal threats or ideation or anything else that would have tied it closer to the events?
His brother testified that before her death, I can't remember how recent, I think maybe it was an Easter visit, her brother testified she was depressed and withdrawn. Also, her therapist, who also engaged in some marital therapy with the couple, had diagnosed Vashti with depression. She said that Vashti had, in fact, a history of depressive episodes in her past. The therapist testified that Vashti had no recollection of her childhood before the age of 10, and the therapist believed that Vashti had been subjected to physical abuse, perhaps, or some type of abuse during her childhood, perhaps sexual abuse. She testified Vashti herself believed she had been the victim of sexual abuse. Vashti suffered the devastating loss of her brother at the same time that the father abandoned the family. All that evidence speaks to deep psychological pain, which could support Brett's testimony as well of her history of attempts at self-harm.
And counsel, the two witnesses you just described, the therapist and the brother, I think the question was what evidence did not come in that was contemporaneous? That evidence, none of that came in either? What you just described from the brother and the therapist, I thought
No, that did come in.
It did. So
Yes.
what did,
Yeah, that's in
what
the
was,
record.
What was prohibited from being admitted that would have made it more, made these suicide attempts or ideation more contemporaneous with the crime?
Evidence independent of Brett's testimony of suicide attempts?
Yes.
I'm-
Is there
I'm not-
anything that corroborated him other than him saying that she was still depressed or she was still contemplating suicide?
We've also contended that Brett should have been allowed to introduce testimony of her marijuana use, which may have indicated a depression. Also, we've raised in the brief the trial court's rejection of Vashti's evidence, or of evidence that Vashti was using I think it's called HCG. Actually, that evidence came in, but Brett wasn't allowed to connect the dots for the jury with expert testimony that use of that hormone can cause depression. And
some of the reason that expert wasn't able to be used is because the judge decided he wasn't really an expert. He or she wasn't really an expert on that topic.
there were two areas of inquiry there that weren't allowed. One was from the defense expert, and the judge determined he wasn't qualified and believed that his opinion was based on hearsay. But the coroner testified, and we contend that the coroner was fully prepared to say the PDR is a learned treatise. I use it every day in my work. I consult with the PDR, and the PDR does list depression as a side effect of HCG. And the coroner would have gone too far afield if someone had asked her.
Was there any evidence of that she was currently taking the medication, what she had taken that day, over the week, over the month prior to her death?
There was a friend of Vashti's who testified that within a few days, I believe, of her death, she'd had a conversation. It might have been through email, but she'd been in contact with Vashti, and Vashti had told her that she was losing weight by using the HCG. And that was within a few days of her death. And I remember the witness had said, I was surprised to hear about that. So that's.
And then returning to my colleague's question, she wanted to know whether Mr. Seacat himself would have been able to testify to anything more contemporary than, I think 2008 was the last date of a suicide attempt. Was he going to talk about anything between 2008 and the time of the death?
Independent of the actual suicide attempts, what he would be able to talk about.
What was he prevented from testifying about that might have been more contemporaneous than 2008?
With regard to suicide attempts, nothing.
Okay.
2008 was the last one
Okay.
that he was prepared to testify. I hope that.
Yeah, that covers it. Thank you.
Turning to the question of Vashti's hearsay. Oh, I'm out of time. I didn't realize.
Counsel, would you like 30 seconds to wrap up, or do you believe you've made your points?
Maybe if I could spend 30 seconds on the hearsay statements. We just, in this case, we contend, first of all, the impending divorce gave Vashti incentive to falsify or distort. And we believe that the idea that there was no incentive until the moment the divorce petition was on file was a mistake on the trial court's part. And there was no evidence in the record as to when the threatening statements were made. Therefore, there's no evidence upon which to find that the statements were recently perceived when Vashti related them to her friends and associates.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Chris Elslager, appearing on behalf of the state. And I would say that in light of this court's decisions in Baker and Drach, you cannot say that the district court abused its discretion in following the case law and excluding the evidence of the alleged suicide attempts that took place allegedly some 3 to 18 years earlier.
The definition of relevance is that it's makes the fact to be proved more likely than not.
Yes.
Wouldn't you say that it's more likely than not that someone who has attempted suicide in the past would commit suicide than someone that hadn't?
No, I don't know that. I mean, I'm sure if we looked at statistics, there's probably a fair number of people who commit suicide who never attempted suicide in the past. And there's...
I understand that, and there's arguments to be made about the weight, but arguably, we're talking about the difference between relevance and weight, as brought up by your opposing counsel, and all relevant evidence is admissible.
And what I would submit to you is that it was not relevant, as this court said in Baker, that it was too remote or tenuous to establish the victim's state of mind at the time of, in this case, her death. What if she had been depressed and suicidal 3, 6, 10 years earlier? People get treatment, people get better. A lot of people who have attempted suicide go on to live the rest of their lives and die a natural death. What her state of mind was umpteen years earlier is not relevant at the time of her death. That's what this court said in Baker, and that was the precedent that the district court was following. And if correctly following the precedent is not an abuse of discretion. So I think the court correctly excluded that evidence.
Was the evidence being offered to prove her state of mind at the time of her death?
Oh, certainly. That was,
Why couldn't it have been being offered to show a propensity or a pattern of conduct?
Well, I don't know that the defense made that argument.
Okay.
Brett Seacat's defense was that she was suicidal at that time and she committed suicide.
So as a matter of what happened below, the defense argued that it should be admitted to prove her state of mind. Is that what you're saying?
I believe that is correct.
Okay, thank you.
And then if there are no further questions on that matter, I'll move on to the discussion of the experts. The coroner basically said, I'm not an expert on HCG. I don't feel comfortable answering. I can't answer those kinds of questions. And so to suggest that by handing her the physician's desk reference, she would suddenly become an expert in HCG when she said she's not, I think is a bit of a stretch. Just because it's in the physician's desk reference doesn't mean that the person can suddenly discuss it.
How do you use a learned treatise?
Well, I think you'd need, it depends on the treatise, but the physician's desk reference is a treatise for experts, for physicians. So it takes it requires a bit of interpretation and explanation. I think you wouldn't go to an orthopedic surgeon and say, hey, I've got a skin condition here. I know you don't know anything about it. Can you just look in the book there and tell me what drug to take? I don't think an orthopedic surgeon would diagnose you on that. I don't think you just take the book and say, oh, well, it says here you do this. I think he would recommend that you go to a dermatologist.
Well, if you had the expert in the field on the stand, why would you need to learn a treatise? And I know there are circumstances under which you can use a learned treatise is admissible. And I thought that was if you can have someone testify as to its bona fides and its use by experts, not the actual expert.
Well, but they were essentially wanting to backdoor expert testimony in by getting her to read from the PDR and essentially submit that as her expert opinion, and she wasn't comfortable doing that. Again, not every learned treatise is the same. This treatise is for experts and requires some interpretation and application by those experts in the particular field. It could be used to bolster a certain expert's testimony, especially if you had dueling experts and that sort of thing, but you didn't have that here. What you had was a coroner saying, hey, that's not I don't know anything about that. I can't answer those questions. So it was not, again, not an abuse of discretion for the trial judge to recognize that the witness said she couldn't answer the question, and wasn't an expert, and did not allow it in. I think that was the rational, reasoned decision. I think it would have been irrational to go the other way. And then, if there are no further questions on that point,
Well, let's talk
I guess-
about the hearsay and the out-of-court statement. 6460D3 requires that the matter has been recently perceived by the declarant while the declarant's recollection was clear. It's
Yes.
basically what is required by that. Do we know when the out-of-court statements were made?
well, it depends
There's
on
kind of
the
two prongs to
statement.
that. When did the defendants allegedly say those to Vashti, and then when did Vashti then relate those to the various witnesses who testified about the threats? Do we know a time frame? What do we know about those?
Well, it depends on each statement. Each statement needs to
Right,
be looked at
of course, yeah.
independently, but in general, we know that it was within the 6 months prior to her death, because they were made to the to the counselor in the course of the counseling sessions in the 6 months prior to her death. They were made. The co-workers were able to testify. It was made just within a couple of weeks to a couple of months before her death. We know with the dream statements, which of course the state contends were not preserved for appeal, but that aside, we know from the preliminary hearing testimony that Vashti's sister said she called her just within the day and said this just happened, and
That's what is there evidence somewhere that suggests that in that situation?
In that
yes,
situation,
this just happened.
yes.
That was a couple of days within the.
And that was information that the district judge had before him when making the decision on whether to admit the evidence. And as set forth in the brief, this court's precedent says that recently perceived requirement in D3 allows for a considerable passage of time. It doesn't have to be contemporaneous.
Right.
So as long as it's reasonably, and the case also says that the judge has a lot of discretion in determining whether it's recently perceived. And I think when you balance that too with the consistency of the statements, there's a lot of indicia of reliability to those statements, and I would say they're somewhat similar to State v. Murray. I've cited that in the brief. I realize that it's not an exact fit, but it's close. Especially the statements to the marriage counselor. So I would offer that as additional support for the judge's decision. Ultimately, it's an abuse of discretion standard, which would require this court to overturn only if no rational jurist would agree with the district court. These issues were litigated in front of the district. At least some of them were litigated in a motion in limine. The district court considered the arguments of counsel, considered the evidence, and made a decision. Now, some of them, of course, were not objected to, and the district court never had an opportunity to make a decision on those, and that's why the court should not review those particular statements. And then if there are no further questions, that would conclude my argument. I would ask the court to affirm the district court and affirm the convictions and sentence.
I have a quick one. My notes aren't very good. There was the defendant made a statement during with the fire going on and in the chaos of the moment that he had pushed his wife to suicide. Statement. Do you recall that? Here's my question. I can't tell from my note whether that was from the preliminary hearing, suppression hearings, or whether that was actually testified to at trial by either whoever he said it to or by.
It was, I believe it came up in the interrogation or somewhere along the line. He said I bullied her or something like that. I don't recall if that was in the
I'm just trying to figure out
suppression hearing or if it's not, if it was in the trial.
I was just trying to figure out if the jury heard that. Okay, well,
I don't
maybe-
know.
Maybe
I
we
just,
can get that on
I
rebuttal,
mean,
or I can
my-
look it up later, but I'm trying to factor, I'm still having trouble with the different, getting this to a problem of law rather than an abuse of discretion. And, to me, it seems like an abuse of discretion to have excluded this evidence, and the defendant's argument is that it's a question of law, and I'm still wrestling with that. So we'll figure it out. Thank you.
Any more questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you. Justice Biles, I believe the jury did hear that statement, and I believe it was in the defendant's recorded interview that was played for the jury. I'd like to thank counsel for reminding me what Baker says. Baker says that the evidence should be admitted unless it's too remote or tenuous. And we believe that that distinguishes this case from Baker because the evidence of previous suicide attempts, while tenuous in Baker, was not tenuous at all in this case. And Justice Steele, I had thought about your question as well about habit or propensity or custom evidence, and I would note that 6449 and 6450 do allow evidence of habit or custom if it's relevant to an issue of behavior on a specified occasion. Of course, that wasn't the argument at the district court level. Turning to the argument about Vashti's hearsay statements, Justice Rosen, I'd like to go back to your timing question, and just because there are so many different variables in this, I'd like to...
and numerous statements.
Numerous.
Or at least 4 or 5 anyway.
Right.
And different statements, but they're similar.
Right. I want to concentrate on what we consider to be the most prejudicial statements. The statements that Vashti made to Scott Hankins and Melissa Beasley in April, sometime during the month of April of 2011.
Right. And those were that he spoke of that he would kill her, burn down the house, and make it appear as if she did it. And he said that to Miss Beasley and Mr. Hankins.
That's correct. Well, Vashti said that to those two people.
Right, exactly.
And those are certainly the most prejudicial statements. So we have evidence, we have a 30-day time period in which she reported the statements, but we don't have any evidence at all as to when she perceived these threats. At the trial court, the state's attorney asserted, without offering any evidence, that it occurred sometime in January or in February. And I think the state has recognized this problem in the proof in their brief because they have basically just said, well, it's reasonable to assume that, I'm trying to get the wording right, it's reasonable to assume, or it's a reasonable inference that when Vashti made these statements to other people, she was relating something that had recently happened. So the state is asking this court to just make some assumptions about facts that are missing from the record here that renders this extremely prejudicial hearsay evidence admissible without the benefit of cross-examination in this case. And even if you accept the trial prosecutor's assertion, oh, these threats occurred in January or in February, that leaves us with this wildly speculative timeline of, well, there was either a lapse of about 30 days if we assume the threat was made at the end of February and reported at the beginning of April, or 120 days if we assume the long timeline that the threat was made at the beginning of January and reported at the end of April. So based on this highly speculative timeline that is not supported by evidence in the record, we contend that the trial court abused its discretion when it found that the statements made by Vashti were made at a time when she had recently perceived the threats.
Can I clarify your position also as it relates to the 6455 aspect of the motion in limine? I've looked at the transcript, and the transcript seems to indicate both things were happening at the same time. And in fact, in some cases, the trial court ruled that under 6455, this comes in under the state's theory, and then dealt with the hearsay, and then vice versa. In the continuing objection that was raised during trial, it's most likely preserved. The court recognized the motion in limine, said, well, that, and had a continuing objection. But then in your brief, in this case, you really don't talk about the 6455 aspect, so you're not contesting that. Does any of this come in independent of the hearsay and just pursuant to 6455, or does it have to clear a hearsay hurdle first?
Absolutely. Absolutely. I thought the state's argument on this point was extremely creative by saying, well, it's admissible under 6455, therefore we don't have.
So it has to be otherwise admissible, and then that's your position.
Right. I would just say this, 6455 and 6460 are both statutes of exclusion, and we exclude two different types of evidence. We're not contending there's a 6455 barrier, so that barrier drops, but we still have a 6460 barrier, and the evidence has to comply with a exception to the hearsay ruling.
Before it can be considered under
Correct.
6455. Okay.
Correct.
Thank you.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.